Welcome to Huddleston Boland's short video seminar series on the Fair Labor Standards Act. The series includes 4 short videos on wage and hour compliance, the Voluntary Compensation Settlement Program, requirements for nursing mothers, and preparing for and managing a Department of Labor audit. Our speaker is Ashley French. Ashley is a partner in our Charleston, West Virginia office and practices in the Employment Law Group. This video discusses preparations for and how to manage a Department of Labor audit.
The Department of Labor has increased its investigative force by 50% since 2008. In 2011, these new field agents recovered over $225 million in back wages. That's an increase of 30% over the preceding year. Some of the target industries include construction, hospitality, janitorial services, flaggers, warehousing distribution, staffing companies, and gentlemen's clubs. Well, first, the employer needs to establish a wage and hour program and then make sure that their records are well kept and they're updated. Take a look at the classifications for each employee, make sure they're properly classified as exempt or non-exempt. Take a look at their job descriptions and the actual job duties. Just because a job has a certain title and that title might lead one to believe it's exempt, it might actually be a non-exempt position considering the duties that are involved. Also, make sure that you perform some self-audits and ensure that all overtime has been paid and that if there are any payment violations, that those are remedied. An inspector from the Department of Labor may give advance notice of an inspection, but they don't have to. The inspector can just show up at any time. If that would happen and the employer does not feel prepared, they can request that the Department of Labor come back maybe within 72 hours or so. Again, the Department of Labor doesn't have to honor that request. If an employer is adamant that they do not want the inspection to take place at that time, they would want to contact their lawyer because they can make the Department of Labor go and get a search warrant before coming onto the premises for an inspection. An employer would also want to ensure that any interviews and inspections take place at reasonable time so it doesn't interrupt the workflow or the work day. The employer should also actively participate in the investigation by attending all meetings, all conferences, and all interviews that the employer is allowed to attend. The employer is not allowed to attend all interviews, especially if it's a lower level employee or salaried employee, but any managers and supervisors, the employer is usually allowed to attend the interview. The employer should also make sure that detailed notes are being taken by someone who's the designated note taker. And anything the inspector looks at or anything the inspector asks of an employee and who they interview, all these things should be documented in those notes. If the inspector has asked for documents, the employer usually has at least 72 hours or so to gather those documents, but at the same time should contact their attorney or work with different department heads to make sure that no information is being disclosed that wasn't requested and that any documents that have proprietary information are properly redacted or protected, possibly under a confidentiality order if necessary. Finally, the employer should be prepared to provide at least 3 years of payroll records. After the inspection, the Department of Labor auditor will usually contact the employer or the designated contact person, whether that's their attorney or someone else. The auditor will advise of any violations that were found during the process and the amounts of any penalties. If the employer wants to contest the violations or negotiate a settlement, they want to be sure to contact their attorney first and see what the best way to go is. Also, the employer should be aware things that may have passed the Department of Labor inspection may not pass the state inspection. That especially is true with the classification of independent contractors. The employer should ask for a detailed report from whoever was handling the inspection on its behalf, whether that be the attorney or some other person, just so that it's aware of any issues that might come up in the future.
Thank you for joining us for this informative video. Please don't hesitate to contact us at Huddleston Boland for more information or to discuss your legal needs.